A very good afternoon to all learned judicial officers from Punjab, Haryana, and UT. On behalf of Chandigarh Judicial Academy, I, Harshali Chowdhary, faculty member cum additional district and sessions judge, welcome you all in today's webinar. The topic we chose for today's webinar is with regard to the circulated judgments passed by Honorable Supreme Court and Honorable Punjab and Haryana High Court to us as judicial officers for the year 2020, 2021 and 2022. Without further ado, I shall start with my presentation on such judgments. Now, the first judgment is in re policy strategy for grant of bail. This judgment pertains to Order 20, Section 21A CRPC, which deals with plea bargaining, Probation of Offenders Act 1958, and Section 320 CRPC. Now, in this judgment, Honorable Supreme Court had issued directions with regard to the disposal of criminal cases by resorting to triple method of plea bargaining, compounding of offences, and the Probation of Offender Act. Detailed guidelines as well as directions are issued by Honorable Supreme Court as to how to deal such kind of cases, what kind of cases can be taken into consideration for disposal, and who shall be the competent officers who will deal with such cases. In the said judgment, Honorable Supreme Court has stated that from each district, one CJM, one judicial magistrate, and one officer in the rank of additional and session judge shall be holding a court for dealing the cases by applying the triple method for the disposal of such cases. The time period for compliance of this judgment is approximately given for 4 months, in which in the first month, after identifying the judicial officers, training of the judicial officers will be given by the academy and the cases would be identified. Notice to the party shall be given with and a period of 1 month will be given for that, and the matter is to be considered within the period of 2 months. So this is the judgment in re policy strategy for grant of bail. Another judgment was passed by our own Honorable Punjab and Haryana High Court in Ashima Khetarpal versus Dinesh Setia, in which directions were issued to the family courts as well as court of Ilaka magistrate, which are seized off with the FIR case that proceeding under the Protection of Women from Domestic Violence Act to accommodate the respondent husband with a single date, so that his appearance in all cases is not moved in once in one calendar month, and as and when all the matrimonial cases are so adjourned, especially when the cases are transferred to a court as requested by the wife. Another case judgment is of Honorable Supreme Court in the case of XYZ versus State of Madhya Pradesh. In this case, Honorable Supreme Court has laid down the duties and responsibilities of the trial court to deal with the aggrieved persons in sexual offences cases before them in appropriate manner. In the case of Jagjit Singh and another versus State of Punjab, our Honorable Punjab and Haryana High Court had said that the accused who has been sentenced and convicted and sentenced for various imprisonment, his sentence was suspended by High Court during the pendency of the appeal, and consequently he was ordered to be released on bail forthwith on furnishing adequate personal or surety bonds to the satisfaction of the learned Chief Judicial Magistrate or duty magistrate. However, learned magistrate did not act upon the order passed by Honorable High Court. It was observed that there was no reason for CGM or duty magistrate, as the case may be, to not to act upon the order of the court. In case there was any glaring ambiguity in the order passed by the High Court, the court concerned could have sought clarification in that regard, and failing which there was inordinate delay in releasing of the accused, which is in clear violation of rights to life and personal liberty under Article 21, courts have to act upon the order, are required to be more sympathetic and considerate qua implementation of bail orders in letter and spirit so as to give speedier relief to the person concerned. Now, another case is Seva Singh versus Balvinder Kaur. It's a civil case decided by Honorable Mr. Justice Anil Chetarpal, wherein he categorically held that there is no requirement that the original document must be kept in the record or file of the court. It is sufficient to bring the original for the perusal of the court by the party, which can be examined and returned by the court while keeping its copy on record. It was further held that whenever the documents are exhibited in the evidence, the presiding judge is required to record as to whether the primary evidence has been produced or not. If a copy is placed on the file of the court, but the primary evidence is shown to the court for comparison, which on being examined is found correct, then there is no requirement of keeping the primary evidence on the court file. Also, it was observed that a wrong practice has been established by the courts to adjourn the case for cross-examination, which not only results in the wastage of the precious time of the court, but also causes inconvenience to the parties and to the witnesses. Hence, the courts can preferably insist upon the supply of a copy of the affidavit to the other party a day or two before the date fixed or evidence so as to grant sufficient opportunity to the opposite counsel to come prepared for cross-examination. Now, in the case of Amit Kumar through Ella Sushila Devi, Hon'ble Punjab Haryana High Court laid down the principles of law as enumerated vis-a-vis Section 389 CRPC and Section 148 NI Act. Kathukandi Edathil Krishnan versus Kathukandi Edathil Valsan and another is a case by Honorable Supreme Court, wherein it was held that once a preliminary decree is passed by the trial court, the court should proceed with the case for drawing up the final decree suo motu. After passing of the preliminary decree, the trial court had to list the matter for taking steps under Order 20, Rule 18 of CPC. The court should not adjourn the matter sine die. There is also no need to file a separate decree proceedings. In the same suit, the court should allow the concerned party to file an appropriate application for drawing up the final decree. Needless to state that the suit comes to an end only when the final decree is drawn. Therefore, directions were issued for the trial court to list the matter for taking steps under Order 20, Rule 18 CPC soon after passing of the preliminary decree for partition and separate possession of the property suo motu without requiring any initiation of any separate proceedings. Meaning thereby that now once the preliminary decree has been passed, we are not required to wait for the party to move an application for drawing the final decree, but the suo motu steps be taken by the trial court for drawing up the final decree in the case because the suit will come to an end only after the drawing of the final decree. Another case is Darshan Singh versus State of Punjab by our Honorable Punjab and Haryana High Court, wherein Honorable High Court had reiterated the guidelines laid down in the case of Rajesh Yadav and another versus State of UP, and also Honorable High Court had also referred to the guidelines issued by Honorable Madhya Pradesh High Court in the case of Ram Bohar Saket and others versus State of MP in order to have speedy trial and to check delay of recording of the prosecution evidence. The following guidelines have been issued by the court that after framing of charges against the accused, summons be issued to the eyewitness, or if it is a case where there are no eyewitnesses, then to those witnesses who are most material to prove the case of the prosecution. If summons are returned unserved for whatever reasons, instead of wasting further time by resorting the same process time and again, the next summons must be served through the Office of Superintendent of Police to the witnesses, where the trial court is situated in the district headquarters, and through the office of the SDOP in the Tehsil courts. If those summons are also not served, the report of the police must reflect the reasons why they have not been served. If the reasons given by the police in the report returning the summons unserved reflect that the witnesses are unreachable or untraceable and that service cannot be effected on them on account of their non-availability, and there is no prospect of them being found within the reasonable time, then the trial court must skip those witnesses and proceed to the next set of witnesses by issuing summons to them. The trial court must realize that the case of the prosecution is actually the case of the state through the police against the accused persons. It is the duty of the police to produce their witnesses before the trial court. By skipping a set of the witnesses, the court is not closing their evidence, but merely keeping them in abeyance to be recorded as and when they are found by the police or appear on their own before the trial court at any stage before the conclusion of the trial. In such a case, skipping of such witnesses would necessarily need the consent of the counsel for the defense, and if opposed by the defense counsel for whatever strategic reasons the defense may have, then the court may issue fresh summons to the same set of witnesses. However, in such a situation, the delay in conduct of trial would then be on account of conduct of the defense for which the accused cannot claim violation of the right to a speedy trial at a later point of time. If material witnesses cannot be procured without delay, the court must explore the possibility of examining formal witnesses and expert witnesses, if any, and conclude the same. Thereafter, the remaining witnesses for the prosecution who have not been examined on account of the inability of the police to produce them for reasons reflected in the report of the police, the court must close the case of the prosecution and proceed to the next stage of the case. However, if any of the prosecution witnesses appears at a subsequent stage before passing of the judgment by the trial court, the court shall be free to exercise its jurisdiction under section 311 CRPC 1973 and record their statements in the interest of justice after considering opposition of the defense counsel, if any. The police on its part must secure the mobile number and email ID of all the witnesses if they possess the same. This must be retained by them in the inner case diary to be used for transmitting the summons or messaging the witnesses regarding their date and time of appearance before the trial court to testify. The police must take care that the aforementioned details are not disclosed in the charge sheet in order to ensure that the access of the accused to the witness is minimized to the greatest extent possible. The trial court must also resort to the option of delivering the summons through SMS and email in addition to the conventional process wherever possible. The purpose of the endeavor must be to secure the presence of the witness in the shortest possible time to complete the trial. The courts must bear in mind that as long as the trial is in progress, the presumption is always of innocence and not of guilt. It shall not be open to the police to put forward reasons of law and order work or any of their functions and excuses for not complying with the order of the trial court to secure the presence of their witness. Such non-compliance on the part of the police may constitute contempt or the trial court's order, and the trial court shall be at the liberty to initiate such proceeding against the police as if it is not satisfied with the reply of the police for not complying with the order passed by it. So if we read these guidelines, it gives us a clear path as to how the service of the witnesses are to be procured and in what order the examination of the witnesses are to be taken place. Another case is of Jatinder Singh alias Happy versus State of Punjab, which is on the NDPS Act. SG Wombatkere versus Union of India is a case by Honorable Supreme Court in which directions were issued with regard to the dealing of cases under section 124A IPC. it was directed by Honorable Supreme Court that if any fresh case is registered under Section 124A IPC, the affected parties are at the liberty to approach the concerned court for appropriate relief. The courts are requested to examine the relief sought, taken into account the present order passed as well as the stand taken by Union of India. All pending trials, appeals, and proceedings with respect to the charge framed under Section 124A IPC be kept in abeyance. Adjudication with respect to other sections, if any, could proceed if the courts are of the opinion that no prejudice would be caused to the accused. Another case we have of Honorable Supreme Court in re to issue certain guidelines regarding inadequacies and deficiencies in criminal trial, wherein directions were issued with regard to the disposal of bail applications by Honorable Supreme Court. In this case, it is directed by Honorable Supreme Court that the application for bail in non-bailable cases must ordinarily be disposed of within a period of 3 to 7 days from the date of first hearing. If the application is not disposed of within such period, the presiding officer shall furnish reasons thereof in the order itself. Also, copy of the order and the reply to the bail application or status report by the police or prosecution, if any, shall be furnished to the accused on the date of pronouncement of the order itself. The bail order should be furnished by the prison authority to the accused also. Another case is Kulwant Singh alias Sajjan versus State of Punjab, wherein our Honorable High Court issued guidelines with regard to dealing of bail applications, regular or anticipatory vis-a-vis verification by the parties, Ahmed as well as prosecutions. In this judgment, it was laid down by Honorable High Court that it shall be ensured by all the session judges of Punjab, Haryana and UT Chandigarh that in the bail application, regular or anticipatory submitted in the session division, the helmet attached with the respective court should verify from the official website of the Punjab and Haryana High Court, Chandigarh, as to whether any bail application qua the same applicant in FIR or complaint is pending or decided before the High Court or not, and the status of the same, if any. After verifying the aforesaid, a report be placed on the case file for the perusal of the concerned court. It must be mandatorily mentioned in every bail application as to whether such similar application for bail has or has not been made before any other court. In case the same was made, the status be also mentioned. The Director Prosecution of State of Punjab, Haryana and Union Territory Chandigarh shall instruct the public prosecutors of their respective states that they shall be duty bound to supply necessary information to the concerned court regarding pendency or decision of any earlier bail application of the accused in the same offence after taking information from the concerned IO or police official. It was also directed that the instructions issued by this court from time to time be complied with meticulously. Now, in the case of Sukhdeep Kaur versus State of UT Chandigarh, minimum time period is prescribed for service of summons or execution of warrants. Direction is issued to all the courts falling within the jurisdiction of this court, that is Honorable Punjab and Haryana High Court, to ensure that sufficient time is given to the summoning agency or the police who has to execute the warrants, normally not less than 10 days, for reports on such warrants or summons issued if the area of service is within state of Punjab, Haryana and UT Chandigarh and Himachal Pradesh, and as regard with other states, 15 days would normally be given for doing the needful, except in cases where there is genuine urgency, in which case of course shorter dates would be given, but by giving cogent reasons. The judgment of Sheila versus State of Maharashtra, Amrik Singh versus State of Punjab and Janki Prasad and another versus State of Haryana was recirculated by Honorable Punjab and Haryana High Court, in which The directions were issued to the magistrates that whenever a person is arrested and taken into custody by the police without warrant, he has to be immediately informed of the grounds of his arrest as required under section 50 of the Criminal Procedure Code. When a person is arrested by the police will give intimation of the fact of such arrest to legal aid cell of district concerned. Whenever any illegal detention is brought to the notice of the sessions judge by any person, the sessions judge of the district shall make a surprise visit of police lockup to find out whether any person is detained in the police lockup without being produced before the concerned magistrate in contravention of section 57 of the Code of Criminal Procedure and the constitutional provisions as contained in Article 22. In the case of Rajesh Yadav versus State of UP, directions are issued to the trial courts to make endeavor to complete the examination of the private witnesses of both chief and cross on the same day as far as possible. The trial courts were further directed to take up the examination of the private witnesses before the proceedings with the official witnesses. In the case of Smriti Tukaram Barade versus the state of Maharashtra and another, directions were issued pertaining to the matter relating to the recording of evidence of vulnerable witnesses in criminal matters. Later on 8th of April 2022, scope of the vulnerable victim deposition scheme was expanded for further jurisdiction, including civil jurisdiction, family courts, juvenile justice boards, and children courts. Permission was also granted for recording the vulnerable witnesses in cases across all jurisdiction. We, Chandigarh Judicial Academy, had conducted a separate webinar on how to record the witnesses, vulnerable witnesses in the court, and that webinar is also available on our YouTube channel. So for detail, you can always visit to in that channel to know about the law. In recognizance for extension of limitation is a case by Honorable Supreme Court passed during the course of COVID pandemic, and certain directions were issued with regard to the calculation of the limitation period due to COVID-19 pandemic. Also, court of its own motion versus Union of India. It's a civil writ petition based on the public interest litigation, wherein several directions were passed by our Hon'ble Punjab and Haryana High Court from the year 2020 till 2022 during the subsistence of COVID in the country. Suresh Chand versus Ajit Singh Dhaya is another case in which Honorable Punjab and Haryana High Court held that the court at first instance, while awarding multiple sentences of imprisonment in a trial, must specify in clear terms as to whether the said sentences would run consequently or concurrently, and in case they were to run consequently, the sequence in which they would run. Rajbir versus State of Haryana is another case of NDPS Act passed by our own Punjab and Haryana High Court, in which it was held that Ganja Pati would fall within the definition of section 23B of NDPS Act. The expression Ganja Pati used by the police cannot confer any right upon the petitioners to escape from the definition of Ganja. Sakina Begum versus State of Haryana is a case in which Honorable Punjab and Haryana High Court passed the directions with regard to the constitution of the committee in each sessions division headed by the Chief Judicial Magistrate in each district, with the Ilaka Magistrate having the jurisdiction of the area of the concerned police station as one of the members, and advocate from Bar Association to dispose of the unclaimed vehicles lying in the police station for the period of 1 year as on 1st of November 2021 in the first instance. So this is all about the judgments in the year 2022 that we have received so far. Now coming to the judgments for the year 2021. So the first judgment that I would like to bring your notice to is Satendra Kumar Antil versus State Central Bureau of Investigation in another. In this case, Honorable Supreme Court, for the purpose of disposing of the bail applications, whether regular or anticipatory, categorized the criminal offences in four parts, wherein part A deals with offences punishable with imprisonment of 7 years or less, not falling in category B and D. B category would be offences punishable with death, imprisonment for life, or imprisonment for more than 7 years, and offences punishable under special act containing stringent provisions for bail like NDPS, PMLA, UAPA, companies, etc. as category C, and category D would be economic offences not covered by the special act. So all the offences were categorized in four parts. Further, the requisite conditions were also laid down for dealing with the bail applications, that the accused is not arrested during investigation, or he has cooperated throughout in the investigation, including appearing before investigating officer whenever called. Now, how category cases given under category A are to be dealt with, how the cases under category B and D are to be dealt with, and how the cases under category C are to be dealt with for the purpose of regular or anticipatory bail application was given in detail by Honorable Supreme Court. Also, Honorable Supreme Court agreed to the suggestion given by learned Additional Solicitor General that such offences which have not been covered by the special act, such economic offences which have not been covered by the special act, in order to determine as to whether to grant bail to the accused or not, both aspects have to be taken into account, that is seriousness of the charge and severity of the punishment. Thus, it is not as if economic offences are completely taken out of the aforesaid guideline, but they form a different nature of offences, and thus the seriousness of the charge has to be taken into account, but simultaneously the severity of the punishment imposed by the statute would also be a factor. Another case is of Pawan Kumar versus State of Haryana by our own Hon'ble Punjab and Haryana High Court, in which directions were issued by Hon'ble Punjab and Haryana High Court, thereby observing that this court cannot lose sight of the fact that there would be certain cases where an accused is unable to appear before the trial court on account of genuine reasons, saying on account of having noted the date incorrectly or on account of certain reasons which are beyond his control. In such cases, the accused can surrender before the trial court, and it is expected that the trial courts would take a lenient view in genuine cases and decide the regular bail application expeditiously. In a given set of circumstances where the trial court is satisfied that there are valid reasons for the absence of an accused and that he has surrendered at the shortest possible time, the trial court can in fact dispose of the regular bail application on the very day the same is presented by the accused upon his surrender. The trial court in its discretion may also choose to grant interim bail as in fit cases, but only after surrender of the accused. Again, court on its own motion versus Union of India, CWP PIL 77 of 2021. Various orders were circulated, passed by Hon'ble Punjab and Haryana High Courts as COVID guidelines for us during COVID-19 pandemic. Jasveer Singh versus State of Haryana is another case by Hon'ble Punjab and Haryana High Court, in which the issue with regard to the cancellation report and the untraced reports was discussed in detail. Detailed guidelines were issued to the police, to the courts, magistrates concerned, to the learned session judges as to how to deal with the cases of untraced reports and cancellation reports. We have separately conducted a webinar on cancellation reports, taking into consideration the law laid down by Honorable High Court in Jasveer Singh. The said webinar is also available in on our YouTube channel. And a separate blog is also there on our website. So for more detail, you can always visit either of the two for clarity and for further guidance in the future. Husanpreet versus State of Punjab is a law by Honorable Punjab and Haryana High Court. And similarly, Vijay Kumar alias Vijay versus State of Punjab is also a law laid down by Honorable Punjab and Haryana High Court, again with respect to the directions for accepting and entertaining the bail applications. So in this judgment, Honorable Punjab and Haryana High Court had laid down certain directions for the court. So far, the anticipatory or regular bail application comes before the trial courts for the decision. It stated that in each and every case, when an application for bail is made before the courts below under any of the provisions of Code of Criminal Procedure, it shall be mandatory to mention in the application as to whether such or similar application for bail under any of the provisions of the Code of Criminal Procedure has or has not been made before any superior court, and if at all a superior court has been approached for similar relief, and the result thereof. An application which does not contain the aforementioned information shall not be accepted or entertained and would be returned for resubmission with necessary information. It needs to be also clarified that the public prosecutor or prosecuting agency shall be duty bound to apprise the court concerned before whom the bail application has been moved after collecting the necessary information from the investigating officers with respect to the filing of any application or petition before any court seeking concession of bail under the provisions of Code of Criminal Procedure and the result thereof. In case of any lapse or default on the part of the investigating agency or prosecution in the said regard, it would be construed to be a fraud played upon the court, which could invite departmental as well as penal action against the erring party officials, as the case may be. So now it is mandatorily being directed to us for entertainment of the bail application, that certain formalities are to be fulfilled by the applicant, by the advocate, as well as the prosecution agency. Rahul S. Shah versus Jinendra Kumar Gandhi and others is a judgment passed by Honorable Supreme Court, especially with regard to the execution in civil cases as to how to deal with them. So in this case, if I briefly tell you about the fact, in this case, the vendor and her sons, after executing the sale deed in respect of a major portion of the property, questioned the transaction by a suit for declaration. The decree holders also filed a suit for possession. During the pendency of those proceedings, 2 sets of sale deeds were executed. The vendor's suit was dismissed. The decree of dismissal was upheld at the stage of Honorable High Court 2. On the other hand, the purchaser's suit was decreed and became the subject matter of the appeal. The High Court dismissed the appeal, the first appeal. The Supreme Court also dismissed the appeal, that is the special leave petition. This became the background for the next stage of proceeding, that is execution. Execution proceedings were subsisting for over 14 years. In the meanwhile, numerous applications, including criminal proceedings, questioning the very same documents that were subject matter of the suit were initiated. In between, the portion of the property that had been acquired became the subject matter of land acquisition proceedings and disbursement of the compensation. That became the subject matter of writ and contempt proceedings. Various orders of the executing court passed from time to time became the subject matter of writ petition and appeal in the High Court, and all those were dealt together and disposed of by the common impugned order. So there was a delay of execution of 14 years, which made Supreme Court to pass certain guidelines for the trial court for the speedy and expeditious disposal of the execution applications. Such guidelines are laid down under para number 41 of the judgment. It said that having regard to the above background, wherein there is urgent need to reduce delays in the execution proceedings, we deem it appropriate to issue few directions to do complete justice. These directions are in exercise of our jurisdiction under Article 142 read with Article 141 and Article 144 of the Constitution of India in larger public interest, and to subserve the process of justice so as to bring to an end of the unnecessary ordeal of litigation faced by the parties awaiting fruits of the decree, and in larger perspective affecting the faith of the litigants in the process of law. Now, directions are: all courts dealing with suits and execution proceedings shall mandatorily follow the below mentioned directions. First, in suits relating to the delivery of possession, the court must examine the parties to the suit under Order 10 in relation to a third party interest, and further exercise the power under Order 11, Rule 14, asking parties to disclose and produce documents upon oath which are in possession of the parties, including declaration pertaining to third party interest in such properties. Second direction, in appropriate cases where the possession is not in dispute and not a question of fact for adjudication before the court may appoint commissioner to assess the accurate description and status of the property. Third, after examination of the parties under Order 10 or production of documents under Order 11 or receipt of commission report, the court must add all necessary or proper parties to the suit so as to avoid multiplicity of the proceedings, and also make such joinder of cause of action in the same suit. Fourth, under Order 40, Rule 1 CPC, a court receiver can be appointed to monitor the status of the property in question as custodia legis for proper adjudication of the matter. Fifth, the court must, before passing the decree pertaining to the delivery of the possession of a property, ensure that the decree is unambiguous so as not to only clear description of the property but also having regard to the status of the property. Sixth, in a money suit, the court must invariably resort to Order 21, Rule 11, ensuring immediate execution of decree for payment of money on oral application. Seventh, in a suit for payment of money before settlement of issues, the defendant may be required to disclose his assets on oath to the extent that he is being made liable in a suit. The court may further at any stage in appropriate cases during the pendency of the suit, using power under Section 151 CPC, demand security to ensure satisfaction of any decree. Next, the court exercising jurisdiction under Section 47 or under 21 CPC must not issue notice on an application of third party claiming rights in a mechanical manner. Further, the court should refrain from entertaining any such application that has already been considered by the court while adjudicating the suit, or which raises any such issue which otherwise could have been raised and determined during adjudication of suit if due diligence was exercised by the applicant. Next, the court should allow taking of evidence during the execution proceedings only in exceptional and rare cases where the question of fact could not be decided by resorting to any other expeditious method like appointment of commissioner or calling for electronic materials including photographs or videos with affidavits. Next, the court must, in appropriate cases where it finds the objection or resistance or claim to be frivolous or malified, resort to Subrule 2 of Rule 98 of Order 21, as well as grant compensatory cost in accordance with Section 35A. Next, under Section 60 CPC, the term in name of the judgment debtor or by another person in trust for him or on his behalf should be read liberally to incorporate any other person from whom he may have the ability to derive share, profit or property. Next, the executing court must dispose of the execution proceedings within 6 months from the date of filing, which may be extended only by recording reasons in writing for such delay. Next, the executing court may, on satisfaction of the fact that it is not possible to execute the decree without police assistance, direct the police station concerned to provide police assistance to such officials who are working towards the execution of the decree. Further, in case an offence against the public servant while discharging his duties is brought to the knowledge of the court, the same must be dealt with stringently in accordance with law. Directions were also issued to the judicial academies, who must prepare manuals and ensure continuous training throughout appropriate mediums to the court personnel or staff executing the warrants, carrying out attachment and sale and any other official duties for executing orders issued by the executing courts. So accordingly, in view of the directions issued by Honorable Supreme Court, Chandigarh Judicial Academy has prepared a refresher manual for process serving agency with regard to the execution, as to how the execution of the warrant or summons are to be made. This manual would be very useful even for us being judicial officers who are dealing with the execution matter in our day-to-day working in our court work. Another judgment is for the judicial officers dealing with the offences under Section 138 NI Act. It is in reference expeditious trial of cases under Section 138 NI Act. Now, in this case pertains to the direction issued by Honorable Supreme Court. Actually, what happened that there was a special leave petition pertaining to dishonor of 2 checks for an amount of rupees 1,70,000, and the dispute had remained pending for the past 16 years. Now, considering the large number of cases filed under Section 138 of NI Act pending at various levels, the division bench of Honorable Supreme Court, consisting of 2 of the honorable judges, decided to examine the reasons for the delay in disposal of the cases. So accordingly, the registry was directed to register a suo motu writ petition captioned as expeditious trial of cases under Section 138 NI Act. So after due deliberations, etc., the court also observed that even despite of the fact that there are various provisions under NI Act so as to deal with the complaint cases, especially of the dishonor of the check, there is a humongous pendency of the complaint under Section 138 of the Act. The report so sought by Supreme Court showed that the total number of criminal cases pending was 2.31 crores, out of which 35.16 lakh pertain to Section 138 of the Act. The reason for the backlog of the cases was that while there is a steady increase in the institution of the complaints every year, the rate of disposal does not match the rate of institution of the complaints. So delay in disposal of the complaints was given because of the basically 7 reasons. That is service of summons, statutory amendment to Section 219 of the Code, summary trial, attachment of the bank accounts, applicability of Section 202 of the Code, mediation, inherent jurisdiction of the magistrate. So detailed discussion was made in the said judgment on each and every aspect. And also a committee was also instituted by Honorable Supreme Court to look into as to how there can be expeditious disposal of the cases for some policy making. That apart, certain directions were also issued by Honorable Supreme Court as under para number 24 of the judgment. The High Courts were requested to issue practice directions to the magistrates to record reasons before converting trial of complaints under Section 138 of the Act from summary trial to summons trial. Inquiry shall be conducted on receipt of complaints under Section 138 of the Act to arrive at sufficient grounds to proceed against the accused when such accused resides beyond the territorial jurisdiction of the court. For the conduct of inquiry under section 202 of the code, evidence of witnesses on behalf of the complaint shall be permitted to be taken on affidavit. In suitable cases, the magistrate can restrict the inquiry to examination of documents without insisting for examination of witnesses. We recommend that suitable amendments be made to the Act for provisions of one trial against a person for multiple offences under section 138 of the Act committed within a period of 12 months, notwithstanding the restriction in section 219 of the code. The High Courts are requested to issue practice directions to the trial courts to treat service of summons in one complaint under section 138 forming part of a transaction as deemed service in respect of all the complaints filed before the same court relating to dishonor of check issued as part of the said transaction. Judgment of this court in Adalat Prasad versus Subramaniam Seturaman have interpreted the law correctly, and we reiterate that there is no inherent powers of the trial court to review or recall the issues of summons. This does not affect the power of the trial court under section 322 of the code to revisit the order of issue of process in case it is brought to the court's notice that it lacks jurisdiction to try the complaint. Section 258 of the code is not applicable to complaints under section 138 of the Act, and findings to the contrary in meters and instruments do not lay down correct law. To conclusively deal with this aspect, amendments to the Act empowering the trial court to reconsider or recall summons in respect of the complaints under section 138 shall be considered by the committee constituted by an order of this court dated 10th of March 2021. All other points which have been raised by the amici curiae in this preliminary report and written submissions and not considered herein shall be the subject matter of deliberation by the aforementioned committee. So these were the directions or observations issued by Honorable Supreme Court with respect to the expeditious delay or expeditious trial of cases under section 138 of NI Act. Another case which I would like to bring your notice to is Aparna Bhatt versus Aparna Bhatt and another versus State of MP and another. Directions were issued with respect to dealing with bail applications under section 438 as well as 439 CRPC vis-a-vis remarks on the gender sensitization and how the bail applications with regard to the sexual offences are to be dealt with. So in this judgment, if I can bring your notice to, directions were issued that bail conditions should not mandate, require or permit contact between the accused and the victim. Such conditions should seek to protect the complainant from any further harassment by the accused. Where circumstances exist for the court to believe that there might be a potential threat of harassment of the victim or upon apprehension expressed after calling for reports from the police, the nature of protection shall be separately considered an appropriate order made in addition to a direction to the accused not to make any contact with the victim. In all cases where bail is granted, the complainant should immediately be informed that the accused has been granted bail and copy of the bail order made over to him or her within 2 days. Bail conditions and orders should avoid reflecting stereotypical and patriarchal notions about women and their place in society and must strictly be in accordance with the requirement of the CRPC. In other words, discussion about their dress, behavior or past conduct and morals of the prosecutrix should not enter the verdict granting bail. The courts, while adjudicating cases involving gender-related crimes, should not suggest or entertain any notions or encourage any steps towards compromise between the prosecutrix and the accused to get married, suggest or mandate mediation between the accused and the survivor, or any form of compromise as it is beyond their powers and jurisdiction. Sensitivity should be displayed at all times by judges who should ensure that there is no traumatization of the prosecutrix during the proceedings or anything during the arguments, and judges especially should not use any words spoken or written that would undermine or shake the confidence of the survivor in the fairness or impartiality of the court. The further, courts should desist from expressing any stereotype opinion in words spoken during proceedings or in the course of judicial order to the effect that women are physically weak and need protection, women are incapable of or cannot take decisions relating to family, women should be submissive and obedient according to our culture, good women are sexually chaste, motherhood is a duty and role of every woman, an assumption that she wants to be a mother. Women should be the ones in charge of their children, their upbringing and care. Being alone at night or wearing certain clothes make women responsible for being attacked. A woman consuming alcohol, smoking may justify unwelcome advances by men or has asked for it. Women are emotional and often overreact or dramatize events. Hence, it is necessary to corroborate their testimony. Testimonial evidence provided by women who are sexually active may be suspected when assessing consent in sexual offences cases. Lack of evidence of physical harm in sexual offence case leads to an inference of consent by the woman. So these were all the directions issued by Honorable Supreme Court for the judges to be more gender sensitive. We have also conducted a webinar on gender sensitization based on the judgment of Aparna Bhatt, which is again available on our YouTube channel. Now coming to the judgment of Ashwani Kumar Upadhyay versus Union of India, wherein it was held by Honorable Supreme Court that no adjournment shall be granted in except in exceptional circumstances, and that too for reasons to be recorded. Now coming to the circulated judgments of 2020, the first judgment I would like to take up is of Sushila Devi versus State of Haryana and another. In this judgment, displeasure was shown on the illegal encroachment by the encroachers by the land allotted by HSVP. Taluka and district judicial officers were directed that as and when applications were moved on behalf of Chief Administrator HSVP, within whose jurisdiction suits are filed and where interim orders are secured to protect the illegal encroachment committed into the property of HSVP, such applications shall be taken upon priority basis and disposed of on merits within 30 days from the date of application, and wherever it is found that the orders are secured on false and fabricated documents, to vacate the same and to pass an appropriate order for prosecution of the said persons on priority basis. Rajneesh versus Neha and another is a judgment passed by Honorable Supreme Court in which guidelines were laid down on certain aspects pertaining to the payment of maintenance in matrimonial cases. It was observed by Honorable Supreme Court that there are different statutes providing for making an application for grant of maintenance or interim maintenance. If any person having sufficient means neglects or refuses to maintain his wife, children, parents, the different enactments provide an independent and distinct remedy framed with a specific object and purpose. In spite of time frames being prescribed by various statutes for disposal of interim application, in practice, in vast majority of cases, the applications are not disposed of within the time frame prescribed. To address various issues which arise for consideration in application for grant of maintenance or interim maintenance, it is necessary to frame guidelines to ensure that there is uniformity and consistency in deciding the same. So in this judgment, guidelines were issued by Honorable Supreme Court on the issue of overlapping jurisdiction, payment of interim maintenance, criteria for determining the quantum of maintenance, date from which maintenance is to be awarded, enforcement of orders of maintenance, and the final direction. So if I can bring your kind notice to the final directions. First is with regard to the issue of overlapping jurisdiction. Now, to overcome the issue of overlapping jurisdiction and avoid conflicting orders being passed in different proceedings, it has become necessary to issue directions in this regard so that there is uniformity in the practice followed by the family courts, district courts, magistrate courts throughout the country. We direct that where successive claims of maintenance are made by a party under different statutes, the court would consider an adjustment or set off of the amount awarded in the previous proceedings while determining whether any further amount is to be awarded in the subsequent proceeding. It is mandatory for the applicant to disclose the previous proceeding and the orders passed therein in the subsequent proceedings. If the order passed in the previous proceedings requires any modification or variation, it would be required to be done in the same proceedings. With regard to the payment of interim maintenance, the affidavit of disclosure of assets and liabilities annexed as enclosure 1, 2, and 3 of this judgment as may be applicable shall be filed by both the parties in all maintenance proceedings, including pending proceedings before the concerned family court, district court, magistrate court, as the case may be throughout the country. For criteria for determining the quantum of maintenance, payable to the applicant, the court shall take into account the criteria enumerated in Part B3 of the judgment. Striking of the defense of the respondent is an order which ought to be passed in as a last resort if the courts find default to be willful, contumacious, particularly to a dependent, unemployed wife and minor children. Contempt proceeding for willful disobedience may also be initiated. Certain factors were also given with regard to the determination of the quantum of maintenance, which are not exhaustive. Sorry for the interruption. So with regard to the directions issued by Honorable Supreme Court in Rajneesh versus Neha, the date from which the maintenance is to be awarded, we make it clear that maintenance in all cases will be awarded from the date of filing of the application for maintenance. With regard to the enforcement or execution of the order of maintenance, for enforcement or execution of order of maintenance, it is directed that the order or decree of maintenance may be enforced under Section 28A of Hindu Marriage Act 1956, Section 20 subsection 6 of the DV Act, Section 128 of CRPC as may be applicable. The order of maintenance may be enforced as a money decree of a civil court as per the provisions of the CPC, more particularly under Section 51, 58, 55, 60, read with order 21. Next is the judgment of Zulfikar versus State of Haryana. It pertains to NDPS Act. Now, in this case, the issue was with regard to the status of challan, if it is incomplete or not, without the report of the chemical examiner or forensic science expert. So the matter was, after due deliberation, was referred to larger bench by Honorable Justice Shri Sudhir Mittal to constitute a larger bench on the point as to whether it is an incomplete challan if presented without the report of the chemical examiner or forensic laboratory. In the judgment of State of Punjab versus Gurmeet Singh was recirculated by Hon'ble Punjab and Haryana Court, which pertains to the recording of evidence by the prosecutrix. In this case, it was held that while conducting the cross-examination of the victims of sexual assault, the court should be vigilant that the defense counsel should not adopt a strategy of continuing question the prosecutrix as to the detail of rape. The court should not sit as a silent spectator while the victim of the crime is being cross-examined by the defense, and it should effectively control the recording of the evidence. Next judgment is of Ashwani Kumar Upadhyay versus Union of India. In this judgment, it was clarified by Honorable Supreme Court that the pendency of the said matter before Honorable Supreme Court shall not come in the way of expeditious disposal of the cases relating to the selected representatives sitting or former. The case of Savitri versus State of Haryana and others is another case by Hon'ble Punjab and Haryana High Court, wherein it was held by Hon'ble High Court that it is not open to a court inferior to the High Court and the Supreme Court while awarding a sentence of life imprisonment under the Indian Penal Code to further provide for any specific term or the end of the or till the end of the life of the convict, or to direct that there shall be no remission as an alternate to death penalty. For that, Honorable High Court placed reliance upon Union of India versus Sri Haran alias Murugan, the case in 2016, Volume 1, Supreme Court Cases, Volume 1. Vijaypal versus State of Haryana is an exhaustive judgment passed by Honorable Punjab and Haryana High Court, in which the guidelines were issued on the topic of compelling of attendance of witnesses and execution of court processes. Now, in this judgment, Honorable High Court had posed three questions. First was that if the prosecution or the accused applies for assistance of the court in securing the presence of their witnesses whose presence is essential for just decision of the case, can the court decline such assistance and insist that the prosecution or the accused must produce them on their own responsibility? The second question was that if the court issues process for summoning of the prosecution or the defense witnesses, but the concerned police officer or officer of any law enforcement agencies of the state fails to execute the process issued by the court for securing the presence of the witness, can the court close the prosecution or defense evidence without initiating appropriate action against a defaulting officer or official, looking into reasons for non-compliance, taking requisite remedial steps, and making sincere efforts for ensuring compliance with its orders and due execution of the process issued by it? And the third question posed was, if the summons issued by the court for securing the presence of the witnesses are duly served on them, but the witnesses do not appear in compliance with the summons served on them, can the prosecution or the accused be said to be at fault for their non-appearance, and the court can close the prosecution or defense evidence on the ground of failure of prosecution or defense to produce them without taking action against the witnesses failing to appear in the court without any lawful excuse, and also securing their presence in the court by issuing coercive process for their examination in the case. Now, answering all the three questions, Honorable High Court held that if the prosecution or the accused applies for assistance of the court in securing the presence of prosecution or defense witnesses, the court cannot generally decline such assistance and insist that the prosecution or the accused must produce the evidence on its own responsibility. However, the assistance of the court for summoning of defense witness can be declined where the application for such assistance is made for the purpose of vexation or delay or for defeating the ends of justice. If any police officer or any officer or official of any of the law enforcement agencies of the state fails to execute the process issued by the court for securing the presence of the witnesses, the court is duty bound to take appropriate action against the defaulting officer or official for ensuring requisite compliance with its order and due execution of the process issued by it, and the court cannot close the prosecution or defense evidence without initiating appropriate action against a defaulting officer or official, looking into reasons for non-compliance, taking requisite remedial steps, and making sincere efforts for ensuring compliance with its order and due execution of the process issued by it. If the court allows the application and issues process for securing presence of the witnesses, but the witnesses fail to appear in compliance with the process served on them, the court is duty bound to take action against the witnesses failing to appear in the court without any lawful excuse, and also to secure their presence in the court by issuing coercive process for their examination in the case, and cannot close the prosecution evidence on the ground of failure of prosecution or defense to produce them. The court can close the prosecution evidence where there is gross neglect, deliberate delay, or remissness, misconduct frustrating the court process on the part of the prosecution, so that prolonged trial will amount to complete denial of fundamental right of speedy trial to the accused. The court can close the defense evidence when there is deliberate delay to prolong the trial and declined assistance of the court for summoning of defense witnesses where the application of such assistance is made for the purpose of vexation or delay or for defeating the ends of justice. This judgment was authored by the then Honorable Mr. Justice Arun Kumar Tyagi. He had also conducted a separate webinar on the point of compelling of attendance of witnesses and execution of processes last year, and this webinar is also available on our channel, so we can always have a look at that. Tanuj Dhawan versus court on its own motion pertains to the order passed by Honorable Supreme Court on the visitation rights during the COVID. Now, the grievance of the petitioner was that because of the lockdown, the children were unable to interact with their parents, even though they have visitation rights for the purpose. So if they have visitation rights, it was suggested that electronic contact instead of physical visits can be substituted in these times. The parties can arrive at a mutually acceptable arrangement in this behalf. If there is an aggrieved party, the same can approach the Honorable Family Court. So Sheila Agarwal and others versus State NCT of Delhi and others is a judgment passed by Honorable Supreme Court with guiding principles in dealing with applications under Section 438 CRPC. In this case, primarily two questions were framed as they were referred to a larger bench of the Supreme Court. This judgment was passed by 5 judges bench of Honorable Supreme Court. The two questions were that whether the protection granted to a person under Section 438 CRPC should be limited to a fixed period so as to enable the person to surrender before the trial court and seek regular bail, and whether the life of an anticipatory bail should end at the time and stage when the accused is summoned by the court. So answering both the questions, Honorable Supreme Court answered that with regard to question number 1, it is held that the protection granted under Section 438 CRPC should not always or ordinarily be limited to a fixed period. It should inure in favor of the accused without any restriction as to time. Usual or standard condition under Section 437 subsection 3 read with Section 438 subsection 2 should be imposed. If there are peculiar features in regard to any crime or offences such as seriousness or gravity, etc., it is open to the court to impose any appropriate condition, including fixed nature of relief or its being tied to an event or time bound. Answering the second question, it was held that by holding that the life of anticipatory bail does not end generally at the time and stage when the accused is summoned by the court or after framing the charge, but can also continue till the end of the trial. However, if there are any special or peculiar features necessitating the court to limit the tenure of the anticipatory bail, it is open for it to do so. Along with answering these two questions, again, certain principles as guiding principles were clarified, were laid down by Honorable Supreme Court in dealing with the application under Section 438 CRPC. So these are all the judgments which I could lay my hands on pertaining to the year 2020, 21 and 22. All these judgments, we will make all these judgments available on our website. and shall send you the link so that you can access the crisp form of the judgment. And also this recording would be available on our YouTube channel, so that as and when you want to see, you want to refresh yourself on these judgments, you can always watch that. So with that, thank you for your very patient hearing, and till we meet next time, thank you very much. Namaskar.